Now, first off, before you worry, I am, other than the judge, the last lawyer you're going to have to listen to today. So when I first got into this business, like most people, we get out of school, we think we know something, and we quickly realize we don't. I went to somebody who was very experienced, and I said, how do you do this litigation thing that we're trying to do? How do you do this? And I was told, when you have the law, argue the law. And when you have the facts, argue the facts. And when you don't have either, just argue like hell. And that's what you just saw. You saw a very good attorney come up here and try to get you to say, throw something at the wall, don't convict him of this part. But when it comes down to it, you did take an oath. And your oath was to use your good common judgment and apply the law as given to you from the court to the facts. And we can try to redefine things, but guess what? The law defined it for you. We are a system of law. So let me go back. Burglary, arming oneself with dangerous weapon while in the enclosure. This is what we'll call a special instruction, and you have to answer after they've already admitted that they did everything else. So when you go through the burglary discussion, and once you apply your common sense and find him guilty of the burglary, which everyone has now admitted in this courtroom that he did, you then have to ask, did he then arm himself while in this enclosure? And you'll be given an answer, a line on the verdict form to answer yes or no. Mr. Murphy's now asking you to say no when it's clear, and you remember he said, please use your common sense, that the answer is yes. Did the defendant arm himself with a dangerous weapon while in the enclosure? That's the question you'll get. Dangerous weapon means an item that can inflict death or great bodily injury. Now, again, we can't look into somebody's mind. But we can use our common sense. I'll ask you one more question. Can a gun, whether it be a fully automatic machine gun type long gun or a .22 handgun, can it cause death? Yes. There's your answer. Yes. Arm means the defendant knowingly took physical control. There's no question about the physical control. We saw it. He took it. He grabbed it. He had control over it, put it in his bag. Of a dangerous weapon. A gun is a dangerous weapon. There's your answer. Yes. Mr. Murphy asked you a question, and I'll answer it. You obviously get to answer it in the back, but his question was, is this arming himself? Yes. Did he take guns that can kill? Yes. It's very clear. Mr. Murphy said, use your common sense. And he said that, well, isn't there a reasonable hypothesis that when he took the guns, they weren't loaded, that he wasn't arming himself? Look over here. Don't look at what the facts are. This case is so clear. It's cut and dry. Your decision, frankly, I don't think is going to be difficult. Obviously, the burglary has been admitted by the defense. Obviously, the theft of a firearm has been admitted by the defense. Obviously, the burglarious tool has been admitted by the defense. So the only thing we're discussing here is, did he arm himself? Did he arm himself? 18 times he armed himself. Thank you.